Bava Kamma Daf Kuf Dalid discusses the halacha of sending money in the possession of a shliach, of a messenger. Under what circumstances you can trust him. Under what circumstances, if we'll have two basic cases. Case number one is if the shliach was made by the receiver with witnesses, and case number two is if the shliach was made with a letter from the receiver. Can the sender trust that shliach? So let's begin. The Gemara is quoting our Mishnah. The last Mishnah said that somebody owes money. So let's say Shimon borrowed from Reuven, he owes it back to him, or he stole from Reuven and he has to return it to him. So he can't give it to the son or the messenger. He has to give it to Reuven directly. So the Gemara discusses, what if Reuven made a shliach in the presence of Shimon? He made a shliach and he said, here, this is going to be my shliach to receive the money. Can Shimon then give it to the shliach and say, since you made it in my presence, you're obviously indicating to me, the reason that you went out of your way to make it in my presence is to indicate to me that it'll be considered like it got to your hand as soon as I give it to him. Or do we say, no, the guy will say, Reuven will say, the only reason that I made him in your presence is to tell you that I trust him, and therefore, if you trust him as well, you can give it to him, but not that I'm taking responsibility. And the nafka mina is what happens if there's an einus along the way. If something happens to it while the sheikh is carrying it from Shimon to Reuven, is it Reuven's responsibility? If he took responsibility, then it's his problem. And if he didn't take responsibility, just said, listen, I trust him, it's up to you to decide whether you trust him, then it would be Shimon's responsibility, and it's not considered returned. So that's halacha. So the Gemara says it's a machlekes between Rav Chizda, who says that it is a valid shliach of Reuven, and therefore as soon as it gets to the shliach's hand, it's as if it got to Reuven, and if something happens, it's Reuven's responsibility. That's Rav Chizda's opinion. And Rabbah, who says, no, there is no assumed shlichus, it's still the responsibility of Shimon, who's sending it, until it gets actually to Reuven's hands. So now the Gemara wants to bring some proofs. So the Gemara says, first of all, we have a Mishnah that says that if somebody borrows a cow, so the cow has to be transferred, first of all, from the lender to the borrower, and then it has to be returned from the borrower to the lender. So first discussing how it got from the lender to the borrower. So if you send it in the hand of the son, the eved, or the shliach of the lender, or if you send it in the hand of the son, the eved, or the shliach of the borrower, and then it dies along the way, so halacha is pater. Now, there is no responsibility on the part of the borrower. It's not considered like he got it. Says the Gemara, one of the cases we had here is that he sent it on behalf of a shliach of the borrower. That means that the lender gave it the shliach of the borrower. Now, how exactly did he make it the shliach of the borrower? If it weren't witnesses that he made in front of the shliach of the borrower, if he didn't do it in front of him, or do it in front of witnesses so that he knows for sure, then how is the lender supposed to know that he's his shliach? Obviously, there are witnesses, or he did in front of him. Specifically, the Gemara in all these cases is discussing witnesses. So there must have been witnesses, and we say that the halach is that he is pater. That is, the borrower has not accepted the responsibility, even though it was in his shliach's hands. So you see a kash on Rav Chizda, who says that as soon as it's in the possession of the shliach, if the shliach was made in front of witnesses or in front of the other person, then it is in the responsibility. It is considered to be like the guy received it himself. Here you see that it's not. So my answer is no. We're referring to that he was a worker or a collector specifically for the borrower. He was on his payroll full time, or he collected from his field in exchange for working for him, and therefore he knew he was his shliach. He didn't go out of his way and make in him to appoint him as a shliach in front of the other one, and he didn't indicate anything because he never actually went ahead and did that. Next thing I want to bring right from our Mishnah. Our Mishnah had said that if Shimon stole from Reuven and is returning to Reuven, he can't send it in the hand of his son or his shliach. Now, says Gemara, the son of shliach, what are we referring to? How did he become a son or a shliach of Reuven? If it wasn't made with Edim, how's he supposed to know that he's a son, or at least shliach, how's he supposed to know that he's a shliach of Reuven? So it must be that he is a shliach of Reuven, made with witnesses by Reuven, and therefore it's exactly our case. And still you see it is not considered to be returned until it gets to Reuven's hand. Again, it's Gashon of Chizda. So the Gemara here answers, and again, no, it was a worker, either a collector or a worker for Reuven, and that's how he knows. So Gemara says, if that's true, so then in the Seifa of that Mishnah, when we're looking for a situation in which it is considered to be Reuven's responsibility for when it gets to the Shliach's hands. So why do we have to go to a case of a Shliach Beis Din? Why don't we go to a case where he actually made him with Edom? Instead of saying that it was a worker or that it was without Edom, talk about we just made him with Edom, which you're saying the halacha would be then. It would be the responsibility of Reuven. Why do we have to go to a Shliach Beis Din? So the Gemara answers, because we wanted to find a case where there's no difference as to who made him the Shliach. If it was made by the Beis Din, then it doesn't matter, or it was made with a Beis Din, it doesn't matter if it was Reuven who did it or Shimon who did it, it counts as a valid Shliach. If it would just be in front of Edom, then it has to be made by Reuven, who's receiving it, not by Shimon. We want to talk about a case where it's even, doesn't matter if it was Shimon or Reuven who did it. Now, says the Gemara, this assumes that the Tanna of our Mishnah holds that if it would be made by a Beis Din, it doesn't matter if it was the Shliach who did it, if it was the Nigzal, or the Gazlan who did it, if it was Reuven or if it was Shimon. Either way, the responsibility is on Reuven as having received it. Says the Gemara, that conflicts with the Bryce of Shimon ben Elazar, who says that it's only Reuven's responsibility if Reuven made the Shliach with the Beis Din, or if Reuven sent a messenger to take it from the Shliach of Shimon and it already got to Reuven's Shliach's hands. Otherwise, it would not be Reuven's responsibility. Amish is disagreeing and saying that if it's made by a Beis Din, even if it was just Shimon who made it, it would already be Reuven's responsibility. Now, the Gemara has brought the machlokes between Rabbah and Rav Chizda. The Gemara says, two more opinions of Rav Yechon and Rabbi Elazar both hold like Rav Chizda, that they say that if the shliach was made with Edom, it counts as a valid shliach. If it was made by Reuven with Edom, and therefore from the time it gets to Shliach's hands, it's like it's in Reuven's hand and it's his responsibility. Kasha from the Mishnah, the same one we asked on Rav Chizda, that the Mishnah says if it gets to the Shliach's hands, then the Reuven is not responsible. And the Kasha is, if it's Reuven's Shliach, how do we know it's Reuven's Shliach? It must be that Reuven made it in front of Edom. And the Gemara's answer here is one of two things. Either, like we said before for Rav Chizda, that he was his worker, or a new answer, that Reuven actually sent him to Shimon to present himself to Shimon. He said, it could be Shimon's really trying to return it to me. He just doesn't have a trustworthy person to send it with. So I'm sending the shliach, go present yourself to Shimon and say, Reuven sent me, send it back with me and I will take it. That's the case of he sent it with his shliach. And there the halacha is that there is no responsibility for Reuven until it gets actually to Reuven. The Gemara now brings the machlokes between Rabbi Yehuda, Shmuel, and Rabbi Yechanan. So Shmuel and Rabbi Yechanan. What happens if the person is supposed to be receiving monies? Let's see, Reuven is receiving money being sent to by Shimon. So Reuven gives a letter to a shliach, and he says to the shliach, "Take this letter to Shimon. It's signed, sealed with my signature and my seal, and it says in it, give the money to this person who's bearing the letter. I trust him, and he's receiving it from me." Does that count? Can Shimon go ahead and give the money to the shliach based on the sealed letter that he has? So Shmuel says no, Shimon should not give it to the shliach, even if there are witnesses signed on the letter. Yechanan says if there are witnesses, then he could send it with him. So they say, according to Shmuel, he can't send it. So what's the solution? How could Reuven get the money from Shimon? So the Gemara says, should do like the story that happened with Rabbi Abba. What's the case there? So the Gemara brings the incident. Rabbi Abba was owed money by Rav Bar Kamma, and he was far away, and Rav Safra was traveling back and forth. So Rabbi Abba said to Rav Safra, go to Rav Bar Kamma and pick up the money for me and bring it back. On your way back, bring it back to me here. So when Rav Safra got there to Rav Bar Kamma, he met his son Rava, and Rava said to him, do you have a signed signature that it says that when I'm giving the money to you, it's like Rabbi Abba received it already, and the responsibility for any incident that happened is on him. Do you have such a letter? He said, no, I don't have such a letter. So he said, okay, so then go back to him and tell him that he should write for you his kabalti. He should write that it's considered to be as he received it when I give it to you. Then he said, you know what, even if he writes this kabalti, it's not good enough, because maybe you go back to him, he writes this kabalti, you bring it back to me, but while you're traveling back to me, maybe Rabbi Abba, who's old, maybe he dies, and then the obligation is not to him anymore, but it's to his inheritors, and his kabalti that the Rabbi Abba wrote doesn't work for the inheritors, and then if an illness happens on the way, the inheritors will be able to blame us, and there will be no responsibility for it. So therefore, I'm not going to send it to you even if you come back with his kabalti. So what then? So he said, here's what we're going to do. I'm going to be machne it to you with a piece of land. I'm going to give you a piece of land. I got the piece of land. I'm going to be machne you the money, and now it'll belong to you, Rav Safra. If it belongs to you, Rav Safra, then you take it, you bring it, you give it to Rabbi Abba. Like this, I know if something happens, it's not my responsibility because I was already machne it to you. The Gemara says that's a similar thing that Rav Papa did. He was owed 12,000 zuz by the people of Chuzai. They were makne it to Rav Shmuel Bar Abba with a piece of land with the threshold of his house. He gave him the threshold of his house. Makne to Rav Shmuel Bar Abba's shliach. Took responsibility. He brought it and went back to Rav Papa. And in that way, there was no risk to the people who were sending the money. And in that incident, when he brought it, so Rav Papa came out to meet him all the way to a town called Tavach because of the simcha that he had. Now, so this is what Rav Papa did. Therefore, this is also what Rabbi Abba did. And this is also the solution that we should do, according to Shmuel, that you can't rely on a sealed letter. Now refer back to the Mishnah and begin our next sugya. Sugya is, what is the status of chaimish? So halacha is if somebody steals and he swears that he didn't steal and he doesn't owe it, and then he admits that he swore falsely, so he has to pay back not only what he stole, but he also has to add a fifth. And that's what we call chaimish. So the Gemara says, based on our Mishnah and based on another Mishnah, we have three proofs that chaimish, that extra 50 he has to pay, is considered a moment. It's an actual monetary obligation, as if he has the money of the person that he stole it from. That's what that extra 50 is. This is not a penalty or some just an obligation. He actually has the guy's money and he has to pay it to him. Now, Afkamina is, if he dies and he owes the money, his Yarshim have to pay it. Money that you have that belongs to someone else, and the inheritors have to pay that back as well. If it's just an obligation, just a knas or something, they don't have to pay that. And what are the three rayas? So the first raya is that the Mishnah says that the obligation to do a hashav ma'ai, to go return it to let's say it's Shimon who's returning it to Reuven, to go give it to him physically in his hand and not to send it, that applies only to the keren, only to the actual return of what he stole, not to the extra fifth of the chaimish. The fact that you even have to tell me that, says the Gemara, shows that it's real money. Because if it wouldn't be real money, if it would just be a penalty or an obligation, we couldn't be discussing that I have to go return them. For sure you wouldn't. It wouldn't even need a Mishnah for that. And therefore, it's obviously real money. There is a distinction, though, that the rule of Hashav Maya doesn't apply because that's Xeris HaKasav. The second raya that we have is also from this Mishnah. It says that if he later claims that he paid that chaimish, and he swears to it, and then it turns out he was lying and he admits it, so now you have to pay not only that chaimish, you also have to pay another fifth on top of the chaimish. The fact that you could have a chaimish on a chaimish means that the original chaimish is money. You can't have a knas on a knas, and therefore it's the original chaimish's actual monetary obligations. That's the first two rayas to this side. The Gemara now brings a third raya from a different brisa. The brisa says that if somebody steals money from, let's say Shimon stole from Reuven, and he swore, and then Shimon dies, the inheritors of Shimon have to pay back the keren, and they have to pay the chaimish. They are put from a carbon because the chiv of the carbon is on Shimon, and it's a obligation where the person who was obligated had died, so they don't have to bring that anymore. However, they do have to pay the chaimish. Now, the fact that inheritors have to pay a chaimish of their father shows that it is a real monetary obligation that they can inherit. It's not just a knas or an einish. Now, asks Lamar is a contradiction. There's a brisa in a Teres Kahanim that contradicts this and says that the Yarshim do not have to pay the chaimish that their father owed. So let's see that brisa. So brisa is a drasha on the pasuk that says Asher Gazel Asher Ashak, that he stole and that he oppressed. And the brisa says this teaches me not only do the Yarshim not have to pay chaimish if they or their father did not swear, but even if one of them swore, they or the father, and even if both of them swore, you still no obligation to pay chaimish because the Torah says Asher Gazel Asher Ashak, and they themselves did not gazel or ashak. It's who gazel, and it's not them themselves. So this brisa clearly says that there is no responsibility on Yarshim to pay chaimish, even if one of them or both of them swore falsely. And the previous brisa we just brought says that there is. So that's a stira. So the Gemara answers very simply. Rav Nachman says the case where it's chayiv is where they were eventually moida. The case where they're not chayiv is where they are never moida. So when I ask, what do you mean? If they're never moida, then they don't have to pay anything. There is no established chiv at all. Even the keren they don't have to pay. So the Gemara, okay, maybe in Echanami you don't have to pay the keren at all in the brisa that says you're not chayiv. The says, no, we're looking for a reason that you're putter from the chaimish. Obviously, you are chayiv the keren. Can be what it's referring to. Furthermore, we have a brisa that speaks about the fact that you do have to pay for the keren when one swore. The brisa says as follows: it's obvious that where the son swore and the Yarshim also swore that they needed to pay. What if only one of them swore? And what if none of them swore? They still have to pay. So because it says Gzela and Oishek and Aveda and Pekadin, all those things are mentioned in the pasuk we are discussing here. It says so it mentions all those things, and it says Aveda also Aveda Asher Matzah. So it mentions all these things. That's a teaching. In all situations, you need to return it, even if there's no swearing it falsely. Now, as a side note here, the Gemara says, was this a svara or really a drasha from these words? The Gemara says, Rav Huna was saying this sugi over, and his son Rabba said, were you saying this as a drasha or as a svara? And he said, no, it's a real drasha. From all the ex-psukim here, that's the drasha that says you're chayiv to pay the keren and all these. So you see, you are chayiv to pay the keren. So we have to be referring to that you are chayiv to pay the keren. If they were never made it, you wouldn't be. So what's pshat? How could this brisa be referring to a case where no one was maida? So our answer is no. We didn't mean no one was maida. We meant the father wasn't maida. The son was maida. So the father swore falsely. He was never maida. The son went ahead and was maida. There, the son does not have to pay the extra chaimish. So that the Gemara asked one of the cases we said that the son didn't have to pay is even if he swore himself. We said even if they both swore. So if he swore himself and he was maida, so he himself swore falsely and he was maida to it, he should at least have to pay the chaimish on his own personal swearing falsely. So on that, the Gemara answers, we're talking about a case where the stolen object is gone. It's been spent, it's been eaten, it's been destroyed. And therefore, there's no chiyuv to pay chaimish on that. The Gemara says, if that's the case, Yarshim don't have to pay even keren when the stolen object is gone. They only have to return the object itself. If the object is gone, there is no chiyuv to pay the keren itself that the father had stolen. So the Gemara answers, the case is where there was a lien on it. The thing is gone, but there was a lien that the Ruvain had, the Nigzal had. So Gemara asked if there was a lien on it, there was a chayis and a chasim, then, and here we have machlekes what the girsa is, according to the girsa we have, which Rashi does not like, then it's a milva al peh, it's a verbal agreement, and a milva al peh, a verbal agreement, it's not really a verbal agreement, it's like a verbal agreement because there's no shtar, because it was just a stolen thing. The verbal agreement you can't collect from Yarshim, even if it's a chayis, even if there's a lien on it. And that the Gemara answers again, Rashi doesn't like the girsa, that it was already in Amad Bidin, it was already paskin by the Beis Din, and therefore it counts as a milva b'shtar. Now, what the Gemara says next, which Rashi agrees to, except that Rashi skips the two steps before, so the Gemara is answering the original question, the original line of there was a chayis. So the Gemara says, if there was a chayis, or according to our Gemara, if there was a hamada bedin, it was a psaka of the Beis Din, then even the chaimish they would have to pay, even though they didn't swear, even though they were not moeded. There was already chayis l'chasam, or there was already hamada bedin, so they should have to pay even the chaimish. So that the Gemara gives two answers. Rav Huna Beit of Yeshua says, because there's no chaimish on a denial of a payment on land that has a shibud. Rashi explains that the chaimish is for a false shvua, but there's no chiv shvua on karka, and therefore there could be no chaimish on the karka, and that's why he doesn't have to pay the chaimish here, because of the land that's involved. Rava answers a whole new answer. Really, we're not talking about where the stolen object is gone. The stolen object actually exists. What happened is that the father had given it as a bekadin to someone else, so someone else is holding it. Then, when the son swears that he doesn't have it, he doesn't owe it, he's swearing to the truth. He really doesn't have it, he doesn't own it, and that's not swearing falsely. Now, in that case, the object itself that he stole, he does have to return, because it exists and it belongs to Reuven. However, the chaimish, he doesn't have to pay, because his own shvua doesn't count as a false shvua.